Data Use and Access Bill, Lords. Consideration of Lord's message.
Now, I must draw the House's attention to the fact that Lord's Amendment 49B, the Lord's disagreement with the Commons in Commons Amendment 52 and Lord's Amendments 52B and 52C engage Commons financial privilege. If any of those Lord's amendments are agreed to, I will cause the customary entry waiving Commons financial privilege to be entered in the journal. We will begin with the Government motion to insist on Commons Amendment 32, to which the Lords have disagreed, and to disagree with the Lords in their Amendments 32B and 32C, proposed to the words restored to the bill by the Lords' disagreement. I call the Minister to move the motion. Minister Bryant.
Madam Deputy Speaker, notwithstanding the views of the Chinese government, it's a delight to see you in your place. I'm only saddened that I haven't been sanctioned. It feels a shame, nor by Russia, for that matter. Anyway, there's still time, apparently. Madam Deputy Speaker, I'm delighted to be here today to discuss the data bill, which we last discussed in depth a week ago today. I would like, first of all, to express how pleased I am that the other place has agreed to the government's amendments relating to the National Underground Asset Register and intimate image abuse, and I want to pay tribute to all those members of the House of Lords who've taken part in getting that piece of legislation to the place where it is now. I'm glad we've been able to work with them. I'm going to start, first of all, with encouraging the House to agree those amendments before I move on to discuss amendments relating to AI and intellectual property, scientific research and sex and gender in that order. So firstly, on the amendments 55D, 55E and 56B, which were introduced to the bill in the other place by the noble Baroness Lady Owen of Alderley Edge, these amendments place a duty on the face of the bill requiring the government to review the operation of the reasonable excuse defence in the offences of creating and requesting intimate image deepfakes without consent or reasonable belief in consent, to publish the outcome of the review in a report and to lay the report before Parliament. The Government was pleased to support these amendments in the other place, as we share the desire to ensure that the criminal law, and these defences in particular, work as Government intends. Oh, yes.
I thank my honourable friend for giving way, and I think all of us appreciate this amendment because we want to protect vulnerable women, children and anybody at risk of this sort of harm.
Hear, hear.
But with this amendment put forward and the carve-out that we've created with this, would we not look at doing something similar for our creative industries? If we can protect our vulnerable people, can we also protect our creative industries from copyright infringement by having a territorial exemption that's in a similar way as we do with the deepfakes?
Yeah. Well, I think she's slightly she's jumping ahead of the gun, if I might say, Madam Deputy Speaker. I will come on to those issues, but I mean, really what I want to do is I want to praise Baroness Owen in regard to this piece of legislation, because I don't think it would have ended up in this bill if it had not been for her. There was a bit of toing and froing between the Ministry of Justice and her to make sure that we got the legislation in the right place. As I said in last week's discussions on this, one of the issues was whether her original version of the second offence really worked in law, and I think she agreed that our version was better, which we tabled in committee here, and now we've been able to tidy up the question of reasonable excuse. Perfectly legitimate question. Why on earth would there be a legitimate excuse, a reasonable excuse for creating or asking one of these images to be created? And we went through those debates previously, but I'm glad that we've come to a settled position between Baroness Owen and the Government, and that's what I'm urging everybody to support here today. The Government made a manifesto commitment to ban sexually explicit deepfakes, and this bill delivers on that promise. For the first time, there will be punishment for the perpetrators who create or ask others to create intimate deepfakes of adults without consent. Secondly, if I might turn to the National Underground Asset Register, it does feel as if this has been a long time coming, and that's partly because the bill, of course, is in its third iteration. Amendment 34 regarding the National Underground Asset Register an amendment was previously tabled in the House of Lords requiring the Secretary of State to provide guidance on cyber security measures, which was rejected by this House. Last week, the Government tabled amendments 34B and 34C in lieu on this topic, which were drafted with the support of the security services. These amendments expand the scope from cyber security only to general security measures, clarify the audience for the guidance and extend its reach to Northern Ireland alongside England and Wales. On all the amendments I've spoken to thus far, I would like to thank noble colleagues and the other place for their work and support to reach agreement on these areas. I would urge colleagues here today to also support these amendments, otherwise we're never going to get this bill through. On the subject of never getting this bill through, of course I give way to the Honourable Gentleman. Right, Honourable.
For getting the bill through is to deliver, one would hope, things like content credentials that firms like Adobe have championed in terms of showing who has produced a file, where the ownership sits, and also whether AI has been used to edit it. Could you confirm whether the bill will deliver on that commitment in terms of content credentials, and if not, why not?
Well, because the bill has never intended to deal with copyright and artificial intelligence at all. There is no provision introduced by the government in relation to AI and copyright at all. And that specific issue, I think, would probably be ruled out of scope if it were to be tabled. Look, there are very serious issues, which I'm about to come on to in relation to AI and copyright. And I know the point he's making about technical standards. If he keeps on talking at me, I'm happy to give way to him again if he wants, but I can't hear what he's saying.
Is particularly around AI being used to change photographs and having, through content credentials or the digital fingerprint, the ability to see that. And the point I'm raising is government has still not themselves adopted that in terms of government's official communications. Why either the bill will deliver that, or if not, why would the government not itself be adopting some of that best practice?
Mr. Bryant.
I'm honestly failing to understand the point he's making, because this bill was not intending and has never intended to deal with the kind of issue that he's referring to. As I say, I think if it were attempted if somebody were to table amendments to that effect, they'd be ruled out of order. The bill doesn't deal with copyright or artificial intelligence. The only measures that are in the bill in relation to AI and copyright are ones that have been introduced in the House of Lords, which I'm about to speak to. Madam Deputy Speaker, I listened carefully. I wasn't able to listen to the whole of the debate in the House of Lords on the other day, but the Secretary of State and myself stood at the bar of the House in the House of Lords to listen to considerable parts of the debate. I want to make two separate but interconnected points about AI and intellectual property in relation to the bill. The first is there is an urgent issue that needs to be addressed. Namely, what is happening now, today, and for that matter, you could argue what happened yesterday and last week and last year and 2 years ago. So let me reiterate, to be absolutely clear, copyright law in the UK is unchanged. Works are protected unless one of the existing exceptions that have existed for some time, such as exceptions for teaching and research, applies, or unless the rights holder has granted permission for their work to be used. That is the law. It is the law now, and it will be the law tomorrow if the House agrees with the government and rejects the amendment that has been tabled by Baroness Kidron and has been supported in the House of Lords. As I have said before, I'm glad that several creative industries have been able to secure licensing agreements with AI companies, including publishers, music labels and others, under the existing law. I want to see more of that, more licensing, more remuneration of creative rights holders.
Thank you. Thank you, Honourable Member, for giving way. And it's wonderful to hear him talk of the importance of copyright and that we have existing laws that we can use. But I wonder if the Minister is aware of the growing concern in industry about the risk of expansive US-style fair use principles creeping into UK practice and what we might do to secure our safeguards. And that we won't allow any erosion by foreign interpretations of fair use to impact our copyright laws.
Well, I'm grateful to my honourable friend. I'm sure she will be aware that the US system of fair use is different from the UK system. Ours has gone back to 1709, I think, was the first of our Copyright Acts, and it has been very solid. I said, I think, when we introduced the bill in the House earlier on, that one of the things that we should be proud of in this country is a succession of different generations have made sure that rights holders are able to protect their copyright. Charles Dickens, interestingly, one of his big battles was not only being able to protect his copyright in the UK, but then being able to protect it in the United States of America, where he felt he had fewer protections. So it's for us to develop our own copyright law in our own country, and as I say to my honourable friend, the law as it is will not change one jot, as a result of what we're intending to do in the bill. I think I probably ought to give way to the chair of the Select Committee, and then I'll give way to my honourable friend.
The Minister for giving way, and yesterday he appeared in front of our Select Committee and he said the best kind of AI is the kind of AI that is built on premium content, and you can't get premium content without paying for premium content. Now, as well as being concerned about the overuse of the expression premium content in that sentence, I'm also concerned about the fact that as we speak there are copywritten works out there being scraped underhandedly by AI developers, some of whom are feigning licensing negotiations with the very respective rights holders whose works they are scraping. Surely now is time to require developers to tell us what copyright works are being used to train their models, what their web scraping bots are up to, and surely he agrees that this Amendment 49 is a very good way to move this forward to see what works are being used to train AI models.
Ms Bryant.
Well, the first thing I'd say to her is I completely stand by everything I said to the Select Committee yesterday. I do believe that the best form of AI is going to be intelligent artificial intelligence, and just like any pipe, good AI will depend on what comes out of a pipe depends what goes into the pipe. And so if you have high-quality data going into AI, then it will produce high-quality data at the other end. And I say this because I'm aware of quite a lot of publishing houses in the UK. I think it's Taylor and Francis particularly that I've spoken to, but I've spoken to several other publishing houses. If you just let me finish the point I'm making first, and then I've got to give way to the gentleman over there, and he gets very cross if people queue barge. So I'm aware that there are quite a lot of publishing houses in the UK who are determined to secure licensing deals with the AI companies, both in the UK and overseas, because they want to make sure that those AI companies, A, remunerate them, and B, have very high quality, up-to-date information and data going into them. So that if somebody searches, for instance, about, immunotherapy, for instance, they will have the latest information on immunotherapy, not stuff that is 5, 6 or 7 years out of date or may have come from a very dodgy source. Now, the other point I was going to make, because I said I was going to make 2 points, and I've remembered that I was going to make 2 points. So I've made the first point. The second point is, she said that this amendment would sort the problem today. It wouldn't. It wouldn't do anything today. It wouldn't do anything, actually, for a considerable number of months. So there is an issue about what we do today, what we do tomorrow, what we as a government, and we, for that matter, as the whole of the creative industries and everybody working together, do to make sure that we protect copyright under the existing law as it is today.
Pete Wishart.
To the Minister for giving way, and he keeps on saying this. We have existing copyright laws in place which is there to protect the creative industries and our artists, but practically our whole creative heritage has been scraped. There's probably songs in the top 40 that have probably been totally designed by AI. There'll be books in the top 30 or 40 bestsellers that will be based on AI or probably fully AI. This is happening right now. Surely artists should know, and creators should know when their works are being used, and this is why 49B is so important when it comes to transparency.
Several points I'd make. First of all, he's absolutely right that there are works out there that have been used with the use of AI. As I've said several times, I have never thought that the creative industries are in any sense Luddite. I've always thought that they are at the forefront of innovation in so many different areas. I think I referred at the Select Committee yesterday to Fra Angelico. But it's true of every creative industry. They have to innovate to be able to succeed. And if you go to a video games company, they will say that they are using AI all the time, not particularly to save money, but actually to improve the product. And to be able to be at the cutting edge of what they've done. I think even Bjorn from ABBA has said that he's been using AI as well, because that enhances the work that he's doing. And one of the issues that has yet to be addressed actually by anybody so far, in any of the debates that I've seen, either in this House or in the other, but is in our consultation, is what do we do about the copyright status of works that are solely or largely created by AI, because it's a moot point under the existing law and what we should do. So my point is simply that I think that we need to address all of these issues in the round rather than piecemeal, and I'll come on to that point in more substance in a moment. I heard a male voice behind me.
Thank
I do thank the Minister. He's been very generous with his time in respect of me today. I think central to what he's saying is transparency. But does he agree with me that enforceable transparency obligations would reduce that legal uncertainty, deter infringement by increasing the legal risk to AI developers, enable faster redress by allowing the courts to establish precedent where copyright is breached?
Well, yes, look, I don't think that people should breach copyright law. I've said that in several debates, and that is the settled view of the government. We believe that people should not breach copyright law. People should not break the law. Now, some of those issues have been or are being tested in the courts, and will be contested more in the courts, I think, over future months. And one of the points I made right at the beginning, when we introduced the consultation on this, was I made the point that we have fair use system in the United States of America, we have our system in the UK, and then there's a slightly different system in the EU, which has largely relied on the Napoleonic Code understanding of what an author and what a work is. All of those are slightly different, and in different countries have been implemented in different ways, and they may come to different conclusions in some of these individual court cases. I will in a moment. In some of these individual court cases, and that's why we've wanted to look at every single element of this, through from transparency, technical data, access to data, high quality data, and the issues of enforcement, personality rights, a whole series of issues, many of which have yet to be addressed in either of these debates. But it takes me back to the point that I don't think this is the bill in which to do this piece of work. And I don't think the amendment that we're debating today will secure what people hope from it.
I thank the Minister for giving way. The Minister mentioned the consultation. Could the Minister confirm that the Government no longer considers an opt-out model its preferred approach to copyright and AI? And if so, what alternative approach is now being actively pursued or developed with the sector?
So I'm going to say two things again. The first is that we always said that we were consulting on a package. And part of that package was getting to a technical solution so that rights holders will be able to protect their rights better in a way that was I will in a moment, but I'm still answering this one, if she doesn't mind. And I've got 2 points to make on this one, and I'm probably now going to forget the second point. So it was always going to be a package of measures, and we always said that we wouldn't introduce that package unless we were secure in the belief that we were going to be able to deliver for the creative industries a technical solution that made it simpler for them to be able to enforce their rights, seek remuneration, and would lead to more licensing. So that is a whole package. She will also know that in the last debate that I had on this, I said 2 things. That, well, first of all, that we were going to be open-minded about where we are in relation to the consultation, and secondly, and perhaps just as important, we've said that one of the amendments, I think it was Amendment 16 or 17 when we were last debating this, that we would be doing an economic impact assessment of all the different options that were included in the consultation. I hope that answers my honourable friend's question. And somebody else wanted another question. I think it's at the back, and then it's probably over there.
So I'd like to thank him for giving way. The other week there was an Observer article which reported that a source close to the Technology Secretary said proposals to introduce an opt-out system of copyright rules was no longer his preferred option, but of several being considered. This is potentially a very welcome change of heart, but it doesn't mean anything unless ministers are prepared to repeat it in Parliament. So will my honourable friend confirm this is an accurate of the government's position?
Bryant.
I'm going to, I'm afraid, repeat what I just said. First of all, that we introduced the whole what we introduced in the consultation was a package of measures, and it hinged on this issue of whether we were going to be able to deliver not only for AI companies but also for the creative industries to be able to protect their rights more effectively than they presently can. And secondly, that, as I've said, I think now twice at the dispatch box, we are open-minded about the responses to the consultation. I think we've had 11,500 responses to the consultation. We are making our way through all of that. There are a lot of different issues that have been addressed. interest. I would say that the issue of the economic impact assessment is a serious one, because it's one thing to say, well, the AI company or sector in the UK, we're the third largest in the world, it's worth X billion pounds to the UK economy, and the creative industries, a number that has been used by a lot of people, is worth 124 billion pounds to the economy. It's quite a different matter to draw a proper economic assessment on the impact assessment on the basis of the various different options. I'm afraid he's in a queue, and it's quite a long queue at the moment, and it seems to be getting longer. No. I think the Honourable Lady is next.
I thank the Minister for giving way. And on the point around finding a solution in the round, I do wonder, if no credible technical solution is in sight, will the Minister confirm what non-technical legislative or regulatory measures the Government's considering to protect rights holders in the interim?
Minister Bryant.
Well, that's precisely why we need to do this in the round rather than just piecemeal. I understand the attraction of what's on the order paper today, but I say about it, first of all, that I don't think it delivers now the answer that people need now to the issues that the creative industries are facing now. In another debate, we referred to the issue. Hang on. I think, Madam Deputy Speaker, we're going to have to set up a queuing system. I'm not sure that it's popularity, Madam Deputy Speaker. So the important point is that we need to look at this in the round rather than piecemeal. I don't think that what is on the order paper today would actually deliver anything now. It doesn't purport to. It purports to give something in 6, 9, 12 months sometime in the future. So I'm happy to give way to the Honourable Gentleman.
The Minister of giving way, and we can assure him he remains popular as well as generous with his time. But he mentions this government consultation, and it's caused deep and sustained anxiety across the sector. So when can we expect a substantive response to that consultation?
So I wish I could give him a timeline. And the main thing I want to say about the timeline, as somebody who I think all honourable members know, cares passionately not just about the anxiety that has been created in this sphere because of the consultation, but actually about the anxiety that there is for many creative people about their future careers. I 100% get that anxiety, and that's the bigger point that I would like to start. Frankly, I'd like to stop doing the data bill. I'd like to start going out and engaging with my honourable friend for AI to go round to have as many sessions with creative industries and different parts of the sector and with the AI companies, both in particular UK-based AI companies, to work out how we can get to proper solutions to all of this. And until I get the data bill out of the way, it's going to be I'm going to really struggle to do that. And I just would say one other point, which my honourable friend said, because I think of her as a musician, because I think she's a former or still a member of the Musicians' Union. There is a really important part here for the different sectors within the creative industries, because word, image and music and sound will all have to probably need different technical solutions. And that's the kind of nitty-gritty that we need to get into, which we can only really do when we're considering the whole issue in the round rather than just one specific aspect of it. Now, I think Margate calls.
Thank you very much. The Minister is indeed thank you, Madam Deputy Speaker, and the Minister is extremely generous with his time. I'm conscious that the Minister is talking about the possibility that if these amendments were put forward, they would not do anything today. Well, there is an urgency in the creative industries about the fact that the stuff that they create is being scraped now. So can the Minister prioritise transparency by committing at the dispatch box today to introducing enforceable obligations, if not through a statutory instrument, then at least through a clear public commitment that transparency will be central to the government's approach to AI and copyright?
Minister.
I'm grateful to my honourable friend. Number one, I completely get the urgency of this. I mean, in many ways, I wish we'd been addressing this 2 or 3 years ago, because we're actually some way behind other countries in relation to this. Secondly, yes, we will prioritise the issue of transparency in all the work we do as we go forward. I've said that from the very beginning. Transparency is essential to the issue of licensing. Licensing is essential to the question of remuneration. Remuneration is essential to the process of AI being high quality and being effective and being able to be deployed in the UK. All of these things, I think, have to be addressed in the round and together. But she's absolutely right that without transparency, nothing. It's worth nothing. And interestingly, my honourable friend here, the AI Minister, is slightly chuntering in my left ear, which is very helpful because she makes the point that it was the very first thing that we discussed when we first entered into office, both of us in the Department for Science, Innovation and Technology, was how can we get to a place of a resolute piece of legislation that enables greater licensing, enables greater deployment of artificial intelligence in the UK, in particular UK companies, and how can we get greater transparency. So I completely agree. Well, I will, though I've got a gentleman over there.
Again, he is extremely generous with his time. Would he consider, therefore, interim measures or guidance that deliver similar outcomes while legislative options are being explored? That is what the creative industries are looking for.
Well, I don't know what interim measures would look like. I'm always... as the Secretary of State, and well, all three of us from the team have often said, we are open-minded about anybody coming through the door with a good solution. We're in the business of good ideas, and if anybody's got some good ideas, we're happy to look at them. But I honestly can't make the guarantee that she asks for, because I don't really know what interim measures would look like, which weren't legislative, and it is not our intention, and I would urge people to abide by this, it is not our intention to legislate piecemeal in this bill, which is not about artificial intelligence and copyright. Of course, I'm sorry he's been waiting so long.
I'm very grateful to him for giving way, and he's been very generous, so I might suggest that he works on his queuing system a little bit. I understand that the timetable issue is a difficult one, and most things seem to be arriving in the spring with this government. But could we talk about the format? So we're going to have the consultation, and then is it a white paper, and then going into a bill? Is that what it's going to look like? And will that be in the next King's Speech, perhaps?
Minister Bryant.
Well, I'm certainly not going to suggest... well, if I wasn't able to suggest what interim measures were going to look like, I'm not sure that I'm going to be able to please him with suggesting what's going to be in the next King's Speech. I don't even know when the next King's Speech will be. But look, the thing I want to do as the Minister, both for the creative industries and for data, is I want, along with my colleagues in government, to be able to get on with the business of trying to get together the working parties I've referred to, I will in a moment, the working parties I've referred to several times, to get people from the AI companies and the creative industries sitting around the same table to work out what a proportionate and effective system of transparency would look like. Other countries have struggled with drawing this up. The EU is struggling with it at the moment, and likewise in relation to what the technical solutions might be. That's the next stage. At the same time, we are considering what our response to the consultation should be. We've heard what many people in this House and in the House of Lords have said on this issue, and of course we're going to bear all of that in mind, and we are keeping an open mind in relation to that. I can't give him a date for when we'll publish that consultation, but we are working on it as fast as we possibly can.
He told our Select Committee yesterday, it is not for us to give away the labour of other people to third parties for free. So given that the government has now said it's open-minded, and open-minded means that if there is no technical solution, are you open-minded to the idea of legislative solutions to protect copyright and enhance it for all our great creatives? It's not just Abba's Bjorn, it's people in Rochdale, low-paid creatives, and across the whole of the North West and the country.
It's creative industries. One of the very special things about the creative industries as a sector, which have grown faster than the rest of the economy in the UK, and for whom we are hoping to be laying out our plan in the next few weeks in the creative industries industrial strategy, one of the perhaps unique aspects to them is that they do exist in nearly every part of our land. Often they're not very well paid, not very well remunerated, and we want to change that. That is a key part of what we're seeking to do. We also want to make sure that more people can come into the creative industries and realise their ambitions in those areas, and they're not going to be able to do that if they're not going to be able to be remunerated, which is why I've made this point from the very beginning, which is that we want to get to a technical solution, which I think is not very far distant. I think it is a possibility. I wouldn't deride it. It doesn't exist at the moment, but there are those who are wanting to work on it, and frankly, it might be something where somebody might earn a decent penny if they were to come up with this solution, so that all rights holders will be able easily, simply, without great expense, to be able to protect their rights across all AI platforms that are deployed in the UK. I am keen, I'm almost, oh my lord, I'm almost as keen to get on to the next bit of my speech as I am to get the data bill through to royal assent. But I think I probably ought to give way to the honourable lady, and then I come back to my honourable friend.
So grateful to the honourable gentleman for giving way, and I get the sense that he's perhaps needing to go long, and that might be why he's taking so many interventions, and I am happy to assist him in that process. But I wanted to give him an opportunity. I know him well enough, and I know how much he values this place, but I've been slightly concerned by his comments throughout that he's keen to get on with this and get on with it. Would he like to just put on the record that he is first and foremost a parliamentarian, and being in this place is the bit of the job that he values most?
Mr. Bryant.
Well, now the honourable lady was at my 60th birthday. I know it's very difficult to believe. A very long time ago, says the rather ungenerous member sitting at the back. I think she knows me. Honestly, I haven't been asked to go long. I'm simply, because I do believe in parliamentary scrutiny, trying to answer all the questions and engage in a proper debate. And I know that colleagues want to press me on a series of issues. There are some issues that are coming up which they might want to press me on, which are completely different from this. And I'm very happy to be pressed, including by her, as many times as she wants. But I don't think there was really a question in her point, and I think she thought that she was trying to help me go long, and I'm trying to go slightly shorter, so I'll give way to my honourable friend.
Help the Minister for a moment. Colleagues are looking bewildered. I do not know who was and wasn't invited to the Minister's 60th birthday party, in case they're feeling a little bit left out. Minister. Minister.
I mean, I know it's out of order to say that an honourable member is not telling the truth, but Madam Deputy Speaker, you were there. And I accept your apology. I give way to the honourable member.
Thank you. Thank you. The right honourable gentleman has been very generous with his time today and in the process today, and I thank him for that. I understand the government's long maintained that this bill isn't the right time for these amendments, and given the government's anticipated removal of the Lord's amendments today and the use of financial privilege, what definitive action will the Minister take to address the ongoing serious concerns of our world-leading creative industries, particularly on copyright and transparency, and what does he advise those of us seeking stronger commitments to do next? Would the Minister point to any specific timeline, mechanism or legislative tool that will be used to offer the certainty that this sector is crying out for?
Minister Bryant.
Notwithstanding the hilarity, this is obviously a very important matter to a large number of people, and for many people in the creative industry, it does feel like a kind of apocalyptic moment. They think that their careers are disappearing in front of their faces, and I fully recognise that. The moment the data bill is out of the way, what I would like to do, and I know both the departments that I sit in, Culture, Media and Sport and Science, Innovation and Technology, would like to get people back in, as I say, to work on two working parties. One around transparency, precisely what that looks like, in granular detail, because very high-level stuff I don't think really meets the moment. And secondly, the issue of technical standards and technical solutions that might be able to deliver greater access to data for the AI companies, but also access, an ability for creative industries to be able to protect their works. And I should say, incidentally, one of the elements of the amendment that is on the order paper today, which I do have some sympathy with, and something that I want to explore, is this issue that has been raised, I think, first by the honourable gentleman, which is that there's one issue for Getty Images or somebody like that who is able to go to court and protect under the existing law and is able to protect their rights because they have deep pockets and they are able to engage lawyers and all the rest of it. It's quite a different matter for an individual artist who may want to promote their work by putting it on the internet, doesn't want it to disappear from the internet, but also doesn't want it to be scraped, to be turned into another version created by AI of their work. And so I will in one sec, but and then I think, Madam Deputy Speaker, I think I probably ought to move on to the next subject. Oh dear. Let's see what but I take this point very seriously, which is that it's not just about people with deep pockets, it's also about individual artists, and we do want to make sure that they get there. The Honourable Gentleman.
Madam Deputy Speaker, there's little or no doubt that the Minister takes the issue seriously. I think the House will accept that. But would he also accept that what he has been able to say in answer to questions from this side of the House and indeed from his honourable friends will offer the sector actually rather cold comfort? He recognises, as the government does, that this is an issue. He argues that this bill is not the place to resolve it, but gives no strong leadership on the issue to set out a very clear timetable, a very clearly set out direction of travel, sharing with the House his thinking about how these issues could be solved, because there will be a lot of people who are facing this problem today who he is asking to take comfort from his intention to do something at an unspecified time and with the exception of convening 2 working parties. It's not quite enough in order to meet the magnitude of the concern from this vibrant and growing sector, which, as he rightly says, is represented in all constituencies across the country.
Well, of course, I'd like to be able to move faster, but I think this is, as the honourable gentleman said to me last week and said in committee and has said in various different places, this is not an easy knot to untie. And I think it's going to need quite a deal of goodwill from a large number of people to be able to secure something that is a settled outcome that works for everybody. I still believe that there could be a win-win situation, but that will only happen if we can gather everybody around the same table to be able to deliver it. Now, I'm perfectly happy to provide leadership, and I'm perfectly happy to be punched in the nose for providing that leadership if people think that I've got it wrong. But I don't think that that's the problem at this particular moment. Let me just give you one reason why, give the honourable gentleman one reason why I think the amendment that's on the order paper today, for instance, doesn't really work, which is, yes, we're all agreed that we should introduce transparency measures. It's difficult to work out precisely what that would be both proportionate and effective and would work equally for big companies and for small companies. But there's no point in having transparency measures unless you have an enforcement measure. Now, there is an element in this clause which refers to enforcement, but it basically asks the Secretary of State to draw up that enforcement. Well, I don't think we would be able, one wouldn't expect to be able to do that in any other area without a full bill devoted solely to that purpose. So I wish I were able to move faster. I don't want to move faster than is going to be able to secure an outcome. Now, I think I'm going to take one more, I'm afraid, because I've taken so many, and I probably ought to take the chair of the Select Committee.
I thank the Minister for giving way, and his generosity in giving way has made this into a real debate. And I also want to commend him for his determination to bring the tech sector and the creatives, and there are many creatives who are technical and many technical people who are creative, but to bring them together to develop a solution. But can I just urge him to ensure that he works with a wide range of tech companies, because as I've said to him previously, I do not believe that the large tech platforms have the right incentives to develop an appropriate tech solution to this, and that can I urge him to be transparent in how he engages with them, because I would also say to him just finally that the tech platforms refused to appear before the joint session with the DCMS Select Committee that we held and that it is through the transparency that we can have a competition to identify the best and most appropriate technical solution.
Yes, I completely agree. She makes a very good point that many of the creative industries are actually tech. Roughly 40% in the UK of the creative industries are tech, and they are fast growing. They're part of what we really want to incentivise. She makes a good point that we need to talk to lots of different kinds of AI companies, just as we need to talk to lots of different kinds of creative industries. All of those points are very well made, and that is precisely the job of work that I and the team will want to take forward as soon as we possibly can. Hang on, just one other moment. But I've forgotten the other point I was going to make. So,
thank you, Minister. The last for now. Will the Minister make it his policy to include representatives of the creative industries in the technical committees working on AI and copyright reform? How we've gotten to this point is a sense that one department speaks to one people and another department speaks to another people. In fact, the implications are for both sectors, and the attention should be with both in the room at the same time, talking about each other together with the Minister and the department.
I completely agree with everything he just said, and I can make that guarantee. In fact, interestingly enough, when we started this process after the general election, the first consultation meetings that we had, the two of us, we had the creative industries in one room and the AI companies in another, and maybe it would have been better to mix them both up in the way that he's just suggested, but that's precisely the job of work that I want to get on with. Honestly, I can assure him that we are absolutely determined that wherever we possibly can, we will take the creative industries with us. We will be transparent about the job of work that we do. And I just want to slightly lay to rest this idea that there are two departments at war with one another. That simply isn't the case. You have two departments that are trying to work together to achieve a good set of outcomes for everybody at the same time.
And the Minister has been unbelievably grateful in his interventions, but I did just want to point out before he moves on that point is really important, having the AI voices and the creative industries voices in the same room at the same time. He mustn't forget that the reason the creative industries is in such a state of panic and despair about this is because the hair was set running a few months ago by the Department for Science and Technology when they had an AI strategy that was published saying that the copyright opt-out was a way forward to grow the AI industry, and then the government published their consultation where they indicated that the opt-out was their preferred mechanism, despite the fact that it also included prioritising things like transparency. I understand that, but he has to understand that their panic has set in, and words matter, what we say matters, and he needs to do everything he can now to bring that to a close.
Well, as she knows, I'm very sympathetic to the direction of travel that she's trying to take me in. All I'd say is some people think that I'm splitting hairs here now, and that's not my intention, but I've been keen to avoid the term opt-out. We brought forward, as I said earlier, a package of measures. They were reliant on being able to deliver greater control through technical measures for the creative industries and others who had rights to protect. And that's why we refer to rights reservation rather than opt-out. But I take the point that she makes, and I'm sure that we're going to be debating it for some considerable period of time. She's a select committee chair, and there's another one behind me. And I should have said earlier that when I was chair of the Privileges Committee, we produced a report which has yet to be implemented or even discussed in the House about how you could make sure that witnesses appeared before Parliament when select committee chairs wanted to do so. If it's all right with the rest of the House, I might move on to further subjects. So, scientific research or research. I can never work out whether it's research or research. So this is the issue that is embodied in Amendment 43B from the House of Lords. Firstly, let me say that some people have suggested that somehow or other in this bill we are going to be creating a kind of Wild West for research. That is simply not true. We are not changing the threshold for what constitutes scientific research in the bill at all. We are sticking with what has been and is a fair, clear and proportionate measure using the reasonableness test, which is common in other pieces of legislation and is well known by the courts. As Lord Valence also said in the Lords the other day, this amendment, we believe, as tabled from the House of Lords, would go against the good work of the previous government around avoiding unnecessary red tape for researchers. We have a world-class research sector in the UK. We want to empower them. We don't want to tie them up in red tape. That's why we believe that the documents such as the Frascati Manual, which are very useful and interesting in other settings, are not designed to contain legally binding requirements, and that's why we think that the amendment is misplaced. Researchers would need to be able to demonstrate, if this amendment were carried forward, their work's creativity to a legal standard. Creativity to a legal standard. If your work is aimed at testing or reproducing another researcher's results, is it truly creative? Would be a legitimate question. The question takes on a whole new meaning with a whole new layer of bureaucracy when it will be enforced to a new legal standard, as the bill insists, backed up by the potential for huge regulatory fines. Similar issues arise in relation to requirements for research to be systematic and ethical. Both of those words are not words that are necessarily well known in the courts in relation to this piece of legislation. As Lord Winston argued powerfully on Monday, if this had been the law 50 years ago, we may never have had in vitro fertilisation and benefits spinning off from it, including valuable cancer research. These are the issues caused by putting text into a legally binding setting it was never designed for. Of course, I give way. Again.
I thank the Minister for giving way, and could he just explain on that point that the Honourable Lord made in the other place last night, how setting a test of scientific research for the reuse of data would have prevented in vitro fertilisation?
Well, because his point is that by introducing two new concepts into what constitutes research, as opposed to the accepted threshold that exists already, namely systematic and ethical and creative, you are creating a whole new idea of what research is. And in relation to ethical, at the time when he was doing his IVF work, or wanting to start his IVF work, it was generally thought that it would be unethical to explore in that territory, which I think today we would consider to be misplaced. That's why the task of deciding what counts as scientific research, we believe, is best approached by drawing on guidance and the opinion of experts, as the reasonable test allows, a concept which is well understood by the courts. While I sympathise with the intentions in the other place to guard against misuse and the issues that she and I have discussed on several occasions, we believe this is unnecessary, as the bill already contains sufficient and I would argue considerable safeguards. A controller who wishes to change the purpose of processing to scientific research must, first of all, ensure that they are complying with Clause 71's rules on purpose limitation. If the data were collected on the basis of consent, scientific research is not listed as one of those exemptions. Secondly, they would have to ensure that they pass the reasonableness test. And thirdly, they would have to ensure that they have a lawful basis. Fourthly, they would have to ensure they meet the requirements for the safeguards in Clause 86 of the bill. And fifthly, they would have to ensure that the new processing is fair as well as complies with the wider data protection principles in the UK GDPR. I think that that is a very substantial set of safeguards. And the government cannot see how the amendment from the other place will add value on top of all these requirements against misuse. But it will have an effect on genuine researchers, as I've set out, burdening them with red tape and uncertainty and potentially excluding important research. If she doesn't mind, I'm not going to give way now again. I will be summing up at the end of the debate. So if there are issues that she wants to raise again, I will take them. But I think, Madam Deputy Speaker, you'd like me to get to move on. On sex and gender, turning finally to the issue of sex and gender in the context of the bill and the digital verification services measures in particular. I have tabled amendments to remove what was voted in the House of Lords on Monday for the reasons I and Lord Vallance have noted in previous debates. To clarify the understanding of the House, the data accuracy principle requires personal data to be accurate and not misleading for the purpose for which it is being used. The safeguard should ensure that personal data shared by public authorities with digital verification services for the purposes of verifying a particular attribute appropriately confirm that specific attribute in question. Public authorities and digital verification service providers are legally required to comply with this principle at different stages of the digital verification process. Although it is very unlikely, as I said last week, that digital verification services will be used in the kind of cases raised by members of the opposition, this means that if an organisation requests verification of a person's sex at birth, the public authority must not share data which records gender more widely for the purpose of that check. Likewise, digital verification service providers must not rely on data which records gender more widely as part of the verification process in this scenario. This government recognises that there are instances where sex and gender data appear in the same field in public authority data sets. Existing legislation already requires personal data to be accurate for the purpose for which it is being used, and this means that personal data processed as part of digital verification checks must reflect the specific requirements of that check. I would like to assure the House that if the government were to identify an instance where a public authority was sharing gender data mislabelled as biological sex with digital verification services, we would respond appropriately. To reiterate, this government considers the issue of data accuracy of importance and accepts the Supreme Court ruling. This judgment and its effects must, of course, be worked through holistically, with sensitivity and in line with the law. The government is already undertaking extensive work on data standards and data accuracy, which will consider upcoming updated guidance from the Equalities Regulator. I do not think it would be appropriate to legislate in the way proposed without having taken these steps, particularly given the sensitive nature of this matter and the potential to impact people's privacy and their human rights. Finally, Madam Deputy Speaker, I would like to finish by noting the opinion of yourself that Lord's Amendments 49B, 52B and 52C engage the financial privilege of this House, which the government does not believe it is appropriate for this House to waive. I am sure the other place will reflect on this carefully during their further consideration of these issues. I'm grateful to all those who have intervened, and I hope I haven't managed to cut off anybody before their prime. Thank you very much.
Well, that was a substantial opening speech. Point of order, Simon Hall.
Madam Deputy Speaker, you will recall that on Monday, Mr. Speaker took to task the Treasury bench for making very important announcements about changes to immigration, and the fact that those announcements on major policy changes were made to the media before this House. The Honourable Lady, the Member for Aberdeen North, had an urgent question on this issue just this afternoon. Now, at the heart of that is the ministerial code. It's been brought to my attention that this afternoon the Ministry of Justice has announced some fairly major changes, limiting how long some offenders can be returned to prison under plans to ease prison overcrowding, a major shake-up of offenders. Now, it does seem to be that the government is a persistent offender itself in this matter. It strikes me as being arrogantly cavalier that, given the very strong strictures from the chair, that on the day when a UQ is granted, another offence is added to the charge sheet. This is something which should affect and concern all members of this House who are not part of the front bench. That Parliament hears important announcements as they affect our constituents, and the removal of people from our streets through the prison system, etc., and public safety is of concern to all of our constituents, irrespective where we represent. I also understand that there is no indication of a written ministerial statement on this important issue. So I rise, Madam Deputy Speaker, to reinforce the point which has been made over the last several days on this significant breach of the ministerial code, and to inquire of you whether, even at this latest stage on a sitting day, the Chair has had any indication at all of a statement from the Ministry of Justice so that a relevant minister can be questioned upon what this policy means for our constituents.
I thank the gentleman for giving notice of the point of order. And the member for North Dorset is entirely correct to say that the House took an urgent question earlier today on the provisions of the Ministerial Code. Those provisions make it clear that when the House of Commons is sitting, major government announcements should be made to the House first. The point has been made repeatedly from the Chair and most recently, so multiple times most recently, and ministers are accountable to this House and should make every effort to inform this House of policy developments by statements wherever it is possible to do so. Whilst I've been in the Chair, I've had no warning that a statement is due today. The Government, and no doubt the Treasury front bench, will have heard both this point and what I have said just now, and I trust will no doubt act accordingly and with some urgency. Right. The question is that this House insists on Commons Amendment 32, which the Lords have disagreed and disagrees with the Lords in their amendments 32B and 32C, proposed with the words "restore to the bill" by the Lords' disagreement. And I call the Shadow Minister, Dr Ben Spencer.
Thank you, Madam Deputy Speaker, and it's a pleasure to rise to speak in the Lords' Amendment stage of the Data Use and Access Bill. And over the course of debating this bill, I think it's now become customary to thank the work done by those in the other place, and particularly Baroness Owen, in terms of her work on deepfakes, amongst others who have campaigned so boldly in this area. I'll start by speaking to Lords' Amendment 49B. Now, we've been clear that supporting the creative and the AI sectors is not a zero-sum game. We need to support them both. And the Government, through its ham-fisted consultation on copyright and AI, has raised great concern throughout the creative sector, and the resulting attempts to amend this bill have been in response to the mess they have created. At committee and report stage, we set out a series of amendments which focused on the outcome, not process, for a solution in this area. They were based on ensuring the position in law of copyright in this area was clear, the need for proportionate and effective transparency, removing barriers to startups, and facilitating technological solutions via digital watermarking. And it sort of strikes me as quite odd during the previous debate in one of the many interventions, the member for North East Cambridgeshire, who mentioned the importance in terms of implementing digital watermarking at that point in response to deepfakes, but also has relevance in terms of technical solutions, that the Minister then went on to cover broadly the same topics in his opening remarks, despite pointing out to the member from North East Cambridgeshire that it wasn't relevant to the ongoing debate. It just indicates how confused this area has become in this bill and the need for clarity. Now, I'd like to pay tribute to Viscount Camrose, Lord Parkinson, the members of Gosport and Malden and Baroness Kidron, and others here and in the other place for their work on amendments to get a resolution here. Now, we had sympathy with earlier versions of these amendments, but concerns about workability and prescriptiveness. And we've worked with Baroness Kidron to get to a place now that we can support, and we believe that solutions need to incorporate the principles of transparency and proportionality. It's not a perfect solution, but it's more reasonable than doing nothing. And I find it, again, astounding that the main criticism that the Minister has put forward towards Amendment 49B is the fact that it has a running period prior to implementation. And the fact that while people are calling for things to happen now, it's not something that's happening now. I mean, it's an odd way of approaching legislating, where we are, as an opposition, amongst others working with other parties, trying to find a solution to get the Minister out of a hole. I do hope that members across the House support Lord's Amendment 49B today. I'll move on to digital verification services next. And I welcome amendments 32, 32B, 32C, 52, 52B and 52C on sex data accuracy, which received the support of members in the other place. As my noble friend Viscount Camrose said in his speech, it was necessary to retable amended versions of the clauses on data accuracy previously secured in the other place because our amendment here, New Clause 21, wasn't in scope for debate in the Lords. Now, if you forgive me, Madam Deputy Speaker, the Lords amendments are technical and complex, so I would like to speak briefly to our New Clause 21 to explain how this has evolved over time for the benefit of members across the House. Our previous amendment, New Clause 21, would have compelled public authorities to correct the data sets they hold in relation to sex and collect data on the protected characteristic of sex in accordance with the legal definition set out in the Supreme Court's judgment, i.e. biological sex. It would have also allowed public authorities to collect data on acquired sex as recorded on a gender recognition certificate where this is relevant and lawful. It imposed no new obligations in relation to the correction of data held by public authorities. The obligation already exists under UK GDPR Article 5(1)d. It simply put in place a timescale for correcting data on sex. And we know from the findings of the Sullivan Review that this correction is much needed and long overdue. To address a misconception, Madam Deputy Speaker, Amendment New Clause 21 was silent on how sex is recorded in physical and indeed digital forms of identity for those holding a gender recognition certificate. This is a sensitive issue for the 8,500 holders of GRCs in the UK, and we hope that much needed clarity in this area will be given by the EHRC in its guidance due to be tabled before Parliament next month. It will be up for the Secretary of State to make rules as to how this guidance is implemented in digital verification services. However, this issue, while important, does not affect the clear obligation which already exists in law to record data on sex accurately. Amendments 32, 32C, 32B together compel the Secretary of State to examine whether the public authorities that will act as data sources for digital verification system services ascertain sex data reliably in accordance with biological sex and, where lawful and relevant, sex as recorded on a gender recognition certificate. This will prevent inaccurate sex data from being entrenched and proliferated in the digital verification services system. Clauses 52, 52B and 52C give the Secretary of State the power to define in a data dictionary sex data as biological sex and, where relevant, sex as recorded in a gender recognition certificate. This can be applied across the digital verification services system, the register of births and deaths and other circumstances where public authorities record personal data. These amendments are critical for correcting our compromised data sets and sex and will ensure poor quality and inaccurate data does not undermine digital verification services. Madam Deputy Speaker, to be clear, if our amendments do not make it into the Act, this bill will bring forward self-ID through the back door and risk the protections single-sex spaces offer to everyone. Self-ID is not and never has been the position in UK law. I do not understand why the government is resisting these measures. Digital verification systems need to be trustworthy to deliver the benefits intended by this bill. If they are not trustworthy, the system will fail, and I therefore commend these vitally important and much-needed amendments to the House.
I call the Liberal Democrat spokesperson, Victoria Collins.
Thank you, Madam Deputy Speaker. I would also like to join in thanking the work of many members, especially from the other place, in particular Baroness Owen and Baroness Kidron, and actually, of course, the work of many members across this House and that cross-party work, including with the Minister, a lot of constructive discussion on a lot of elements of this bill, so there's a lot in there. But today I'd like to speak specifically to Amendment 49B. I am lucky enough to represent a part of Hertfordshire which is woven into British creativity.
From Grey and Green of Berkhamsted, whose masterpiece Brighton Rock shaped our cultural consciousness, to Eric Morecambe of Harpenden, whose partnership in Morecambe and Wise brought joy to millions, or the music from the Divines in Berkhamsted, which gets us up and dancing. Local artists such as Mary Casserly or Andrew Keenleyside paint our daily lives in ways that bring perspective, colour and joy the way only artists can. Our landscapes in Ashridge and Aldbury have inspired filmmakers from Disney to Harry Potter, and our pubs have been featured in films like Bridget Jones. But today, this creative legacy faces an unprecedented threat. The current situation is more than just alarming. It is threatening the essence of our national identity and our creative economy. We hear concerns about resources for protecting our creative sector, but this argument misses a crucial point. Our creative industries combined contribute £126 billion to our economy, employ 2.4 million people and are growing significantly faster than the wider economy. The question, Madam Deputy Speaker, isn't whether we can afford to protect these industries, it's whether we can afford not to. When we invest in enforcing copyright protections, we are also investing in safeguarding one of Britain's greatest economic assets and competitive advantage on the world stage. The transparency in Amendment 49B are essential and proportionate. They apply proportionately to businesses of different sizes while ensuring our creative powerhouse can continue to thrive and indeed work hand in hand with technology. True leadership in AI means building on respect for creativity, not exploitation. And I'd like to make it clear this is not about resisting technology, it's about recognising value and safeguarding innovation. And that brings me back to home to Berkhamsted. In the heart of my constituency sits the British Film Institute National Archives, one of the largest and most significant film collections in the world, comprising only over 275,000 titles and 20,000 silent films dating back to 1894. A living memory of our national story told on screen. Would we allow anyone to walk into the BFI and take whatever they liked? Would we let them scan, copy and republish those works without permission or compensation? Of course not. So I ask the Minister, why would we permit the same thing to happen in the digital world? This is a defining moment. We can build an AI-powered future that respects and rewards creativity, or we can allow short-term interests to strip-mine the work of generations. The question before us today is simple. Will we stand for a future where technology and creativity flourish together? Or will we allow the foundations of our cultural life and economic prosperity to be hollowed out for short-term gain? I urge the government to stand up for our creators, stand up for transparency, and stand up for the principle that in the age of AI, human creativity still matters. Thank you.
Onwurah. Thank you very much, Madam Deputy Speaker. And I'm advised to speak to clauses 43B on scientific research and on safeguarding and ensuring that the exemptions measures contained in this bill are used for the purposes of scientific research and scientific research alone. Now, at the second reading of this bill, the Minister was unable to address the points I raised because he ran out of time, given the extensive debate on AI and copyright, and rather feels as though the same thing has happened again today. But in the meantime, the Minister did write to me very extensively with a set to address the concerns that I raised. And whilst I don't think all my concerns were not fully addressed, I was convinced that the Minister does not intend, in fact, that the government does not intend for this measure to widen the circumstances under which data can be reused without consent for scientific research. The examples for which I'm concerned are if data would be reused for the training of AI models which were in themselves not contributing to new creative scientific research. And I do think, and I would emphasize, that all scientific research is creative, and even if it's simply reproducing existing findings, that is creating confidence in the stock of scientific knowledge. But I understand that the Minister does not intend to create a Wild West, as he said, and I do hope that in summing up he can confirm specifically that it is not the policy intention or effect of the provisions to enable reuse of personal data for AI. Now, the Minister makes a hand signal. I'm of the view that hand signals are not reflected in Hansard, and the Minister has far greater knowledge of the proceedings of this House than I do, so I suspect he knows that as well. But if the Minister would like to intervene on me, I'd be very happy for him to do so.
I'll respond. I'm being very badly behaved. I didn't want to take more time, but I will respond at the end, and I think she'll be happy.
I'd like to thank the Minister for that inadvertent intervention, and I look forward to my future happiness. And on that basis, I think that we can work together to ensure, with the Select Committee and with his reassurances, to ensure that the bill does enable scientific research using the fantastic data sets which the UK is proud to have, without exposing the public to the reuse of their data for the purposes of training AI models or for other purposes which are commercial purposes which are not within the sense of scientific research. So I'm pleased to see those, accept those. I will be pleased to accept those reassurances, and I would not wish to engage in further ping-pong between the houses on that basis. Thank you.
Pete Wishart.
Thank you ever so much, Madam Deputy Speaker. Just in reference to the earlier exchange, it seems that if you remember the Minister's 60th birthday, you weren't really there, and I really wasn't there. Did I? Well, it must be some. I knew there would be some very good reason, Madam Deputy Speaker. But there we go. We have it in Hansard about why I wasn't there. But, Madam Deputy Speaker, there is a profound disappointment today within the whole creative sector. Every single one of them really believed and hoped that the Minister would appear today with something in the back of his pocket that he would be able to bring out and to give some sort of reassurance to the whole sector, to the many artists and creators right across the country who are extremely anxious and concerned about the direction of the debate and conversations about the use of their work, who are really concerned that some of their precious works that they've spent so much time, effort, blood, sweat and tears into is going to be scraped up and trawled by one of these bots, be ingested by one of the large American tech companies and reappear as some minor mirror of their works. And I think today no one has been satisfied with what has been said today, and he's got one last chance, and I'm really hoping that maybe in that pocket somewhere he'll just give something to the creative industries, that at least give them some sort of hope as we go forward into these next few months and years, because right now they're going into the next few months and years unprotected, and they'll have nothing that they could rely on other than what's in these amendments today, which I know for a fact that the Minister is going to ensure that are voted down. Now, today's a curious day too. I've never seen this before, where financial privilege has been invoked for a particular amendment. It's just, in my almost quarter of a century in this House, I don't think I've actually seen it, and I think I know why it's been done. It's to ensure that the House of Lords don't get another opportunity to bring back this measure once again. But can I just say to the Minister and to the Secretary of State who's shaking his head, they're already designing it. When this goes back down to the House of Lords, it will be coming back once again, and it will be ensure it doesn't invoke any sort of thing, financial privilege, but it is ultimately disappointing that they will not be able to represent the same motion again, because that was their intention, because this amendment has received overwhelming support from everybody across the creative sector, and I really hoped that they were going to be including that today. Now, the only reason that we're here is because it's the efforts of the members in the House of Lords, and I'm usually one that doesn't pay them much of a tribute and respect to what they've done, but they have played a blinder in this, in particular Baroness Kidron, and the way that she's stuck to this agenda to ensure that these amendments have been reasserted into this bill once again. And the reason that they've had to do it is because the government hasn't. They've done nothing to ensure that our creative sector is to be protected. And they say there should be more time as it comes forward. But I don't have that time. We have to act just now. The livelihoods of 2.4 million creators in the UK against exploitation from some of the richest companies in this world. And if we were to continue at this rate, and as I've said countless times throughout this bill, there will soon be nothing left to protect. And the thing is, the government should have acted earlier itself. It should have taken steps to protect creators' rights as a matter of urgency. Instead, it's been left to others to scramble to find a way to try and ensure that we had these vital amendments in a bill that wasn't, as the Minister said on several occasions, designed to address them. Now, the government's amendments today, what they will do, in effect, is set a timeline of several years before any resolution is reached on copyright or transparency. And I listened very carefully, as I always do, to the Minister in what he had to say about transparency today. And I still don't understand why it cannot be done immediately. All they have to do is to tell any of the inventors, creators, copyright rights holders that their work is going to be used and ingested by one of the web crawlers that are in operation just now. That's all they have to do, and it could be done very easily. There is no great technical problem about why transparency cannot be introduced almost as a priority, and possibly within a few weeks. Yes, of course.
I thank the honourable member for giving way, and he's making some important points. As a member of the other place, Lord Brennan said recently, this bill is an opportunity to regulate for AI, a bus that the government should be getting on rather than waiting for another bus several years down the road. This bus is leaving now, along with the opportunity to protect our creative rights. And I wonder if he agrees with me that and shares my concern that the government is going to miss the bus.
Absolutely. I would always agree with the noble Lord Brennan, and somebody who played with him for many years in the parliamentary rock band. I think we all miss him from this particular house, but he was spot on when he said that. We have to act now. And even if the government wants to change copyright law, and I still don't know if that's its intention, and it's something that the creative sector strongly opposes, it will be years before creators have the slightest hope of protecting their work against copyright theft. This is a sector that's seen its work taken, used and exploited by tech companies, and they came into this process hoping that finally they would get some protection, but instead of being heard, they've had their hopes set aside again. Amendment 49B does exactly what the sector has been calling for over many years. The fact it's been brought forward, I think, is a credit to the sustained campaign from our artists in the creative sector who have organised themselves so efficiently and who put such a compelling case. They put such a compelling and knowledgeable case that our constituents have started to understand the complexities of copyright law, and they now realise the value that has in ensuring that the artists that they love, respect and like to listen to make sure that their work will be recognised and they will be compensated for the wonderful works that they did. And despite what the government says, merely enforcing the existing law will not be burdensome for AI firms, particularly as Amendment 49 allows for the transparency requirements to be modified for small AI developers and for all UK registered developers so that they are proportionate. It is this that will prevent startups being burdened with overly onerous regulation. In fact, all this legislation does is put the UK startups on a level playing field with US tech giants who gain an unfair competitive advantage by ignoring copyright law. Transparency will make the legal risk of copyright infringement too great for AI firms to break the law. It will allow court cases to hear cases quickly, establish precedent and kill any argument that there's uncertainty in UK law. If you can see what is being stolen, it is easier to stop it being stolen and to get redress when it continues to be stolen. And it's now up to the government to fix this. If they are serious about protecting their creative industries, and they should be, and I accept that that's what they intend to do, then they cannot stop at working groups and economic impact assessments. That is the bare minimum. It is not by any measure enough. But this, I believe, if this is the last opportunity that we have to put this case as a black day for our creative sector, who would hope that this would be the day that the government would appear with something that would satisfy at least some of their concerns. They deserve that their work is to be protected fairly, and they were looking for anything from this government to see that they were clearly on their side and were prepared to do something. So the government now has a choice, and I think we already know exactly what is going to decide. Remove Amendment 49 being turned their back on the creative industries, or find an actual way to protect our creative sector and make sure that they back it. Thank you, Madam Deputy Speaker.
Minister.
Thank you very much, Madam Deputy Speaker. I was anticipating more contributions from other members, but it's a delight to see you in the chair. And to follow on from the honourable member, I'm not going to speak at any great length, and members will be delighted to hear. First of all, I just want to refer to the matter of financial privilege, because the honourable member referred to it just now. It's not a matter for it's not that the government decides whether financial privilege is engaged. It's a simple matter that is decided by, on advice from the clerks to the chair, because it is a simple matter determined from the from two motions from 1671 and 1678, where basically where there is any financial implication of a bill, or in this case from an amendment that comes from the House of Lords, it is a simple matter as to whether or not the financial privilege of the House of Commons is engaged. I would say in particular in relation to anything which obviously requires a system of enforcement, that is likely to require expenditure, and that's why we would not choose to waive, as in the word W-A-I-V-E, our financial privilege in relation to these amendments today. I will in one sec. Yes, sure.
There was a money resolution that was passed with this bill at second reading, and I looked at the money resolution and there's nothing that says there is any financial limit on any measures which are included in this bill. So I'm a bit confused about why financial privilege has to be invoked on that basis.
Well, we didn't. The thing is that it's not government that invokes financial privilege, it's the House that does it via the Speaker's chair. So I'm afraid that's a debate that we'll have to have it at another point. And much as I love debating all the motions from 1671 and 1678, I think we might move forward. The only point I'd say to him about the contribution he's just made about the creative industries, and he knows that on many of these issues we completely and utterly agree, is if there were a simple way of being able to enforce those rights today, I would seize it. And if he wants to write to me with a suggestion on what that actually looks like, of what we would do today to be able to enforce the rights under the existing law today, then of course I'd be happy to look at it. Madam Deputy Speaker, I also said that I would respond to the point from the chair of the Science, Innovation and Technology Committee. I think I might say this. This bill creates no new permission to reuse data for scientific research. It is not the effect of the provisions to provide blanket approval of the reuse of personal data for AI training under the banner of scientific research. And I hope that that meets some of the concerns that she understandably has. And Madam Deputy Speaker, I hope it's, well, I know it's completely not in order, but I'm going to say it anyway. Just to end at this point, obviously we've discussed some very serious points, but I do just wish that Remember Monday win the Eurovision Song Contest on Saturday evening with their song What the Hell Just Happened. And I wish Lauren, Holly Ann and Charlotte all the best of British.
The question is that this House insists on Commons Amendment 32, to which the Lords have disagreed, and disagrees with the Lords in their Amendments 32B and 32C, proposed to the words restored to the bill by the Lords' disagreement. As many as are of that opinion say aye. Aye. Of the contrary, no. 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 Division! Clear the lobby! question is as on the order paper. As many as are of that opinion say aye. Aye. Of the contrary, no. No. The tellers for the ayes are Gerald Jones and Kate Dearden. The tellers for the noes, James Wilde and Gregory Stafford. Order, order.
And 71. The noes to the left, 98.
The ayes to the right were 371. The noes to the left, 98. So the ayes have it. The ayes have it. Unlock. We now come to the motion to agree with the Lords in their amendments 34B and 34C, proposed instead of the words left out of the bill by Commons Amendment 34. I call the Minister to move the motion.
I move formally.
The question is that this House agrees with the Lords in their amendments 34B and 34C, proposed instead of the words left out of the bill by Commons Amendment 34. As many as are of that opinion say aye. Aye. Of the contrary, no. Aye. Division! Clear the lobby. The question is, as on the order paper, as many of that opinion say aye. Aye. Of the contrary, no. Division of the ayes have it. The ayes have it.
Never vote Lib Dem. Lib Dems don't even know what they're doing.
We now come to the motion to disagree with the Lords' Amendment 43B. I call the Minister to move the motion.
I also move formally.
The question is that this House disagrees with the Lords in their Amendment 43B. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. As on the order paper, as many as of that opinion say aye. Of the contrary, no. No. The tellers for the ayes are Gerald Jones and Kate Dearden. The tellers for the noes, Tom Morris. No, that was the wrong way round, was it? The tellers for the noes, Bobby Dean and Tom Morrison. Order!
304, the noes to the left, 68.
The ayes to the right were 304, the noes to the left, 68. So the ayes have it, the ayes have it. Unlock. We now come to the motion to disagree with Lord's Amendment 49B. I call the Minister to move the motion.
To move formally, Madam Deputy Speaker.
The question is that this House disagrees with the Lords in their Amendment 49B. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Division, clear the lobby. The question is that this House disagrees with the Lords in their Amendment 49B. As many as of that opinion say aye. Aye. Of the contrary, no. No. The tellers for the ayes are Kate Dearden and Gerald Jones. The tellers for the noes, Bobby Dean and Tom Morrison.
The ayes to the right, 297. The noes to the left, 168.
The ayes to the right were 297, the noes to the left 168, so the ayes have it, the ayes have it. Unlock. Order, order. I must now put the questions necessary to bring to a conclusion proceedings on the Lord's amendments. We come to the motion to insist on Commons Amendment 52, to which the Lords have disagreed, and to disagree with the Lords in their amendments 52B and 52C, proposed to the words restored to the bill by the Lords' disagreement. I call the Minister to move the motion. The question is that this House insists on Commons Amendment 52, to which the Lords have disagreed, and disagrees with the Lords in their amendments 52B and 52C, proposed to the words restored to the bill by the Lords' disagreement. As many as are of that opinion say aye. Aye. Of the contrary, no. No. Clear the lobby. Question is as on the order paper. As many as of that opinion say aye. Aye. Of the contrary, no. No. The tellers for the ayes are Kate Dearden and Gerald Jones. The tellers for the noes, Katie Lamb and Richard Holden. Order.
The ayes to the right, 366. The noes to the left, 98.
The ayes to the right were 366. The noes to the left, 98. So the ayes have it. The ayes have it. Unlock. The question is that this House does not insist on Commons Amendment 55, to which the Lords have disagreed, agrees with the Lords in their amendments 55D and 55E, proposed in lieu of Commons Amendment 55, and agrees with the Lords in their amendment 56B. Minister to move formally.
Formally.
The question is that this House does not insist on Commons Amendment 55, to which the Lords have disagreed, agrees with the Lords in their amendments 55D and 55E, proposed in lieu of Commons Amendment 55, and agrees with the Lords in their amendment 56B. As many as are of that opinion say aye.
Aye.
Of the contrary, no. I think the ayes have it. The ayes have it. Minister to move that a committee be appointed to draw up reasons.
I beg to move that a committee be appointed to draw up reasons to be assigned to the Lords for disagreeing to certain of their amendments. That Sir Chris Bryant, Anna Turley, Callum Anderson, Rachel Hopkins, Katie White, Ben Spencer and Victoria Collins be members of the committee. That Sir Chris Bryant to be the chair of the committee. That 3 be the quorum of the committee, and that the committee do withdraw immediately.
The question is that a committee be appointed to draw up reasons to be assigned to the Lords for insisting on Commons Amendment 32, disagreeing with the Lords in their amendments 32B and 32C, disagreeing with the Lords in their amendments 43B and 49B, insisting on Commons Amendment 52, and disagreeing with the Lords in their amendments 52B and 52C. That's Sir Chris Bryant, Anna Turley, Callum Anderson, Rachel Hopkins, Katie White, Dr Ben Spencer and Victoria Collins be members of the committee. That Sir Chris Bryant be the chair of the committee. That 3 be the quorum of the committee. That the committee do withdraw immediately. As many as of that opinion say aye. Aye. Of the contrary, no. I think the ayes have it. The ayes have it. That concludes consideration of the Lord's message relating to the Data Use and Access Bill.